Hi, everybody. Welcome to John's Briefs here again with Tim Forshee from Forshee Law. Had one on the channel not too long ago out of Norfolk, Virginia that, to me, it looked like self-defense as a defensive case, and then guy got prosecuted, mistrialed, prosecuted again, and mistrialed. And then the prosecutor finally said, yeah, I'm not going to get a conviction here, so I'm going to let it go. I want to talk to Tim about what the heck, how does a mistrial happen, and what does it mean?
Firearms Legal Protection is who I trust to help me after a use of force incident. If you're a Firearms Legal Protection member, I will also be on your team as a consulting expert, and you can attend our monthly active self-protection training seminars for free. Check out all they offer to their members at the link below.
So this poor guy, he's just talking on his phone. Next thing you know, the guy yells at him and then pepper sprays him. And he, as he's going away, draws his gun. Don't know that that was a super great answer there, but I understand he's backing up. He's like, hey, leave me alone. Because the guy had said, I got more for you if you want it, or something. And then, so then that guy draws a gun, and the first guy who got pepper sprayed was better at gunfighting. Okay, cool. Well, the prosecutor said, oh no, you went down the aisle at him, and so he prosecuted him for murder.
I disagree with that.
Yeah, but I guess that's the prosecutor's discretion, right?
I just said I disagree with that as though it didn't happen. I disagree with that decision. Yeah, it is. It's up to the prosecutor, and he knew more facts than I do. But
Thomas Binger chose to prosecute Kyle Rittenhouse too, and he shouldn't have done that.
Right, exactly, right. So,
I forget the prosecutor's name who prosecuted Zimmerman. Anyways, bad decision.
Exactly.
So prosecutors can make that decision.
Yeah. If I'm involved in an altercation with a guy who clearly is overreacting and freaking out, and he pepper sprays me, and I'm rendered inefficient, I'm having a hard time breathing, I'm essentially blind, and I know I have a gun in my tracksuit, didn't look like the guy was wearing, am I nervous that I'm one step away, as any police officer will tell you, from having the guy take my gun away from me and use it on me? And the answer is yeah. So if I'm in that situation, am I going to retrieve my gun to make sure that I've got control of my weapon, and then maybe try to find some place where the guy's not going to follow me and leave me alone until I can get my senses back and get my vision back? I don't think that was unjustified for him to draw his weapon and to move away. And it looked like he did move away. And if he's moving towards him at some other later point, the guy's completely disoriented and blind. Of course he's not moving in the direction you prefer that he move in. He's just, it's Brownian motion at this point. He's just trying to get the stuff out of his eyes, So I do think that that it was justifiable. Now, I don't, as far as the shooting the guy, I didn't see the attack really resuming, so I'm not really sure that shooting him was appropriate, but I think that drawing the weapon and seeking a place of cover and stuff, I had no problem with that. But I think shooting the guy, I didn't remember seeing that the guy resumed the attack per se.
Well, so after he pepper sprayed him, then our defender draws his own gun, then the aggressor draws a gun. Well, now we're in a gunfight.
Okay.
And I'm like, okay.
I forgot that he had a gun. That's
he had a gun too. So now we got a gun.
That's
and
correct.
It's a gunfight. Yep. So, okay, fine. The prosecutor presses charges, and the jury comes back with a hung jury. So I had somebody on YouTube ask me this, like, wait a minute, a hung jury is not a mistrial. And I'm like, no, a hung jury is a mistrial.
A hung jury results in a mistrial. A mistrial is declared by the judge because of a hung jury.
Right. Yeah. So if a jury cannot agree. Right. Now, and in criminal cases, they have to have unanimous agreement.
In our state, and I believe most other states, I want to say there might be a state or two out there where it can be 11-1 or 10-2.
11-1 or 10-2. But not in a murder trial, though.
I don't think so, no. I think in capital cases it would definitely be unanimous,
a unanimous verdict of guilt, or even if one juror holds and will not be convinced, well, then we have a jury that can't reach a decision. That then causes a mistrial.
Correct.
And then the person's question became but then why then can the prosecutor retry again?
Because you haven't been found guilty. So since the case was dismissed, it's not double jeopardy. You can reface the same charges again because it didn't go to the jury.
So the jury wasn't able to reach a verdict.
Correct.
So it's like a trial never happened.
Well, here's the interesting thing about it. I find when it's happened to me that second trial is much easier.
Really?
Because I know the prosecutor's bag of tricks now. Also, every answer that the parties gave in the original trial were sworn statements. I can get those transcripts. I can now use those transcripts. I can't tell the jury that it was from an earlier trial, but I can tell the jury, sir, on August 12th of this year, you gave a sworn statement under oath. Do you remember that? Yes. And in that statement, you stated the following, didn't you, sir? And so it's much easier. It's like a wonderful interview that you don't get. I can't interview the victim in Arizona before the trial. I don't have that right. But if the victim takes a stand, which they will, Now I can use everything they said in the actual transcript from the first trial to impeach them in the second trial, and it makes it much, much easier. My prep time is 1/3 as much, and it gives me ammo that I don't have in that first trial. So I gotta kind of feel like the second trial, oftentimes the advantage goes back to the defense on that one. So.
Well, I learned something today.
That's my experience.
That's a cool thing. I didn't realize that could be used.
Yeah.
Now, again, you couldn't mention that
I
it was a
couldn't
trial.
tell the jury there was an earlier trial. That would result in another mistrial.
Yeah.
But I can use statements that were made under oath to impeach or to foster further my case. Yeah.
And so my thing here, if a jury can't agree on a verdict, that's part of a jury's job. Every juror has to live out their conscience.
That's right.
And do I believe beyond a reasonable doubt? I believe more jurors should. If, they sit and they're going to argue with each other, whatever, and they're going to go back and forth about the evidence before them and, want some more.
Which is what
feedback.
we want. We want them to do that, right?
But at the same time, if you go, absolutely not, I'm not convicting on this, and I don't care what you guys say, I'm not convicting on it. So we can sit here for forever. Now, I do think, again, a judge doesn't want to give a jury an instruction that they can come back hung.
Right.
But that's your job as a juror to go into that jury room knowing you can.
If any of you guys have not seen the movie 12 Angry Men with Henry Fonda, the
Such
original,
a great movie.
It's a great movie. It's 90 minutes long, and it really does a great job of showing you what goes on in those jury rooms and how this process is supposed to work in a free democracy republic. It really is. It's a great movie, and it kind of ties in with some of this stuff. You get that one holdout, it was Henry Fonda. And rather than just saying, I don't care what you guys say, I've already made my mind up, I'm not looking at any of the evidence again, I'm not going to vote to convict. I don't think that's the right way to do it either. I think you got to say, what? I could be wrong too. Let's look at the evidence. Let's talk about it. Let's talk about it for days. I'm not going to change my mind unless you change my mind. I'm not going to just give up because I'd rather be home petting my dogs. You guys are going to have to convince me. That's what I want. That's the juror that you want, right?
And you got to know that you are that juror going into the jury.
And the problem is there are people who want to get on juries for the wrong reasons. There are activists that, I think everybody has the right to keep and bear firearms. But in reality, they're very vehemently anti-gun, and they want to bring that agenda into the courtroom, and they basically just answer questions, maybe dishonestly, but certainly not completely honestly, and they wind up on a jury, and then they've got an agenda on that jury, and I've seen that happen, and that's a horrible thing too. We don't want that. But we expect you to stick by your convictions. And if you are not convinced beyond a reasonable doubt, it's your constitutional duty to vote not guilty and not to be swayed just because you'd rather sleep in your own bed tonight than be sequestered for another night in the Holiday Inn.
Yep.
That's not how it's supposed to work. So.
I will also tell you, almost everywhere, I know somebody's going to talk, I know there's going to be comments in this video about jury nullification. And I will tell you, if you are in a jury room and you use those two words together, you will cause a mistrial. Just like that. If you say, guys, jury nullification means we don't have to enforce this law.
Right.
That's a mistrial.
That's right.
Right now. So if you believe in that doctrine, I do believe that it does have a place to say this law is unjust and I will not convict on it. If you say those words, those can be acceptable words. This is unjust.
How about just shut up, don't talk to the press, and vote your conscience?
Right.
Try that.
But I'm telling you, if you go into a jury room and you say, guys, we can, by the doctrine of jury nullification, we can say no on this one and not convict. You've just caused a mistrial. You just kicked yourself out of the jury box is what you did.
And by the way, it's not the same jury the next time around. You're done.
So, you're done. It's a new group of folks. So then, these kinds of things happen. And the second jury, so now if I got two groups of 12 that both said, we can't come to an agreement on this, well, then the prosecutor at least finally got a brain in his head.
Yeah, I mean, again, I don't think I would have prosecuted this case, but this prosecutor tried it twice and then wisely decided not to waste the time and money on the third trial. So I think that was the right decision there, at least finally.
Finally.
I do, to me, and I was a prosecutor, I didn't make charging decisions, I was a baby prosecutor, but my job is to prosecute cases where I believe there's a reasonable likelihood of conviction.
Right.
If I believe there's no reasonable likelihood of conviction, ethically, I'm required not to prosecute in the first place.
Right.
Sadly, a lot of prosecutors don't follow that. They prosecute because it's politically expedient, or it looks good for their reelection, or if they're going to run for governor someday, blah, blah, blah. It's not supposed to be part of the equation, but sadly it is, and we all know that, so we have to live with it.
Alas and unfortunately. So are you at the whim of a prosecutor on this? Some. Yeah. You really are. Yeah. And hopefully this spurs us all, because do I want to bet my future on the backbone of a single juror?
Nope. You don't want to ever bet your future on any juror. Juries are scary, scary animals that hold your life in the palm of their hands, and that's scary. And it's a very expensive ticket to get to ride the E train there too.
And so stay away from that if you can. But I think a hung jury is a part of our judicial system for a reason. And that causes a mistrial, which is from a legal perspective as if it never happened in terms of them being able to retry again.
That's right.
So they can try again, but as your criminal defense attorney told you, you just gave all your cards to the criminal defense attorney.
And that's really helpful.
And that's super helpful for them.
I had a guy in the first trial that identified that said that my client, inexplicably, said that my client had a short stainless steel revolver and he had a Glock 40. And so I put pictures of both of those, and I was able to do that in the second trial, but not the first trial, because I had no idea he was going to say that in the first trial. So I had blown up pictures of a J-frame Smith and a 40 caliber Glock, and I asked the jurors if they thought they could possibly, under any circumstance, confuse those two guns, and it just gave me a lot of ammunition. Sorry to use that term, but it gave me a lot of ammunition that I wouldn't have had otherwise. So that second trial, knowing what's behind the wizard's booth there is helpful. So,
have you ever, as the defense attorney, after the first one, and then the prosecutor's like, we're going to refile charges, but like, hey man, let's have coffee because I think we want to talk about this.
I did that with my case, and the prosecutor was very amenable to that, and he said, you know what, I'm going to offer you a better plea than I offered you the first time around. And by the way, it's my understanding that it was 10-2, and you were the 2, and I'm like, okay, well, my client won't accept your plea, so I guess we're going to have to do this again. And then I won the second time. And so maybe it was 10-2 the first time, but I don't think it was 10-2 against me because I think we had a pretty good case the first time.
It was 10-2.
I'll say that, but I don't know that we were on the losing side of it.
The
point is that, yes, there's always going to be discussion there, and that's appropriate, and you should have that discussion. And a wise prosecutor might realize, well, I clearly didn't have the case I thought I had, so maybe I eat a little bit of crow and offer something that's a hell of a lot more appealing than I offered the first time around. And you better be ears to that. You better listen.
Yeah.
But sometimes egos and politics play a role here. Well, that was just obviously a ridiculous jury. I'm sure the next jury will be reasonable. Okay, I guess we'll get back on.
All right, rock and roll, here we go.
Yeah, so,
well, now you know, a hung jury causes a mistrial, which means they can run it back. Tim, thanks for the knowledge.
As always, buddy, thank you.